allow me to take host?
Excellent, we're recording. So Doug, I kicked this off by kind of recapping the situation with everybody that a lot of times we have clients who don't know the first thing about selling real estate. Second of all, they're helping a loved one and they pass away and they don't know the first thing about what goes into an estate. So sometimes we're the first responder and we ask them, you know, they come to us and say, I have an estate to sell, but they haven't opened an estate. They don't know how to handle it. They don't know anything about estate taxation or the process. So that's why we wanted to reach out to you and see if we can kind of get a nickel tour of the process.
Yes. No, and I appreciate that you gave me a call. I have this kind of broken down into three main questions, which hopefully will be helpful, particularly to everyone as realtors. So the first question I have is, who should a realtor talk to? And I'll give you the standard answer that attorneys like to give to most questions, which is it depends. But it really is applicable in this case. Depends on who you should talk to. And I'm going to take you back to probably things that you had on your exam to get your licensing, but maybe haven't thought as much about since then. Depending on how a property is titled can impact who you need to talk to. So for instance, if a property is titled as joint tenants with right of survivorship, or it's titled as tenants by the entirety, tenants by the entirety is only available for owners that are married. But if one of those owners passes away, their interest automatically passes to the other owners. So if there's a surviving owner, just because someone's passed away, doesn't necessarily mean there's going to be an estate.
Okay.
So you would be talking to whoever the surviving owners are, getting them to sign the agreement of sale, the other listing documents, that sort of thing. If, however, property is owned as tenants in common and one of the owners has passed away, then their interest does pass into their estate. And so there would need to be a formal estate opened and additional documentation. And we'll talk about that a little bit more too. And you've probably run into situations where maybe one spouse has passed away and now the surviving spouse is looking to sell the property. You would, in most cases, there would not be an estate opened in that situation. You would just be dealing with the surviving spouse, having them sign all the paperwork. And at the time of settlement, it would just be that spouse signing the deed to transfer the property. There would be a notation in the deed indicating, that one party has passed away, the date when they passed away. And we'll get into that a little bit more when I get into the second question. So if you're in a situation where either an estate has been open or an estate needs to be open, the person that you want to be talking to is the estate representative, the legal representative for the estate. It is very common. I talk to people all the time, and to an issue that most people are confused about. But when someone passes away, if they had a power of attorney document signed while they were alive, that document ends at the moment they pass away. Okay, so a lot of people will say, well, I was the agent, I was the power of attorney representative, I'll be the one handling things. From a legal perspective, that's incorrect. Because again, that power of attorney document is now void, given that someone has passed away.
So just because you're the POA doesn't mean you're the executor or the administrator.
That's correct. Now, I would say in most cases, when I've prepared estate planning documents for people, usually the person or persons that they're naming as their agent are the same people that they would name as the executor under the will. But not always, and it doesn't have to be that way. Again, the power of attorney document really is no longer operative. And so, you want to make sure you're not just talking to someone who was the agent, but may in fact no longer be the person that will have the legal responsibility for handling things. Until a court has appointed someone or multiple someones, then legally there's no estate representative. So just because someone has the will and says, I'm named in the will as the executor, you're dealing with me. I mean, that's probably who you are going to be dealing with, but until they've actually gotten that will filed and started the legal process, technically they're not the estate representative. So just be aware of that as well. And we'll come back to how do you know that someone is actually the estate representative when we get to question number 2. And just so you're aware of some terms, if a will is admitted to probate, it's filed at a courthouse, and that will name someone to be the estate representative, they're going to be known as either the executor or the executrix. Executor is male, executrix is female. Or if there's multiple people appointed, they could be co-executors, or if it's multiple females, co-executrixes, which is a word I usually try not to use very much and usually confuses people. And it sounds sort of funny, but those are the technical terms. If someone didn't have a will, but there is an estate that is opened or needs to be opened, they are known as either the administrator if it's just one person, or co-administrators if there's more than one person. Okay, so that's a little bit of difference in terminology. And a lot of times you'll hear people talk about personal representative, and I think I used that term already. That's sort of the generic, it's not specifically that there was a will or wasn't a will, but an estate has been opened and there is someone or someone's appointed to represent the estate.
But they're basically the same role. It just depends whether or not they were named in a will as to fill that role.
Correct. It's the terminology. Do we lose everyone?
I lost everybody. No, they're still here. It's just the screensaver popped
Oh,
up.
the
We're good.
screensaver popped up. Okay, so they can still hear us.
Yep.
Yeah, so it's just more the generic term is personal representative. And I don't know that and that's specific to Pennsylvania. Actually, pretty much everything I'm saying here is specific to Pennsylvania. Each state does have its own rules, especially when it comes to estate administration. So you may be dealing with an estate that has been filed somewhere else, but the property is in Pennsylvania. So you may see different terminology or some different documents. What makes sense?
Yep. And that's a whole nother mess.
It is another mess. Yeah, and actually, if an estate is opened in another state, but they're dealing with real estate in Pennsylvania, there needs to be a process started called ancillary probate. So you can't, there still needs to be legal proceedings filed in Pennsylvania if there's real estate here. Okay, you guys probably don't run into that too awful much, but
I've done a few, and one of the main considerations was we're dealing with courthouses in different counties in different states and trying to make sure that all obligations are met. But then there was a requirement to escrow additional funds for the sale of personal property. There was a lot more escrow of funds for taxation and
Yeah.
everything involved.
And I could imagine that being the case, because again, you're dealing, not only with Pennsylvania laws with regard to the real estate, but whatever laws in the state where the person passed away.
Right. So the real property was in Pennsylvania. The personal property was in Michigan. Pennsylvania had to escrow additional funds to pay off any estate tax that had to be paid in Michigan out of the sale of the real property.
Yeah, that's interesting.
So
Yeah.
it
It can get complicated. All right, so again, first question that we've been talking about is who, as a realtor, do you need to talk to? The second question is what documents should you request from the person that you're talking to? Most importantly is a death certificate. That's going to be needed pretty much the whole way through. And when someone passes away, that's the document that almost everyone asks for. In Pennsylvania, and you don't always need to have an original death certificate. It's better if you can get an original. But a lot of times, especially for the sale of real estate, a copy can be sufficient. Because that death certificate isn't really getting recorded anywhere as part of the sale or transfer of real estate. An original death certificate will get recorded anytime an estate is being opened, but that's, hopefully you guys aren't having to do that.
Hopefully.
End of things, yeah. So in Pennsylvania, historically, death certificates were either green or white documents. It says at the top of death certificates in Pennsylvania that it's illegal to copy them. But that really goes to forging a document as opposed to just making a photocopy.
Got it.
I've made photocopies of those documents for 20 years now, and I haven't ended up in jail. So I think you guys should be safe. The new death certificates in Pennsylvania are now blue with kind of gold highlights on them. I guess they're trying to make it more look like the state colors, but
Certificate looking.
yeah. And they're a full page in length. But again, you should be able to tell whether it's a copy or an original that you're looking at. And those death certificates are issued when someone passes away through the Department of Veteran Records. It has no bearing as to whether an estate is being opened, has been opened, is never going to be opened. That's just tied to someone passing away.
So the existence or the possession of that document has no bearing on whether or not anyone has the authority to sell property.
Correct. It is basically just the legal proof that someone has passed away. Most people don't know this, but on the death certificates in Pennsylvania, there is a section of that form that names someone as the informant. And usually they usually try and get the closest relative, so a spouse or a child generally, but it could be anybody, particularly if there's not a spouse or a child named in that document. That can be important for other contexts, but for purposes of real estate, that designation really doesn't mean anything legally for you guys.
Okay.
Okay. So the next document that you want to have if an estate needs to be opened is what's called a short certificate. It's just a shortened version of the original document that's issued by a courthouse in Pennsylvania. I assume that's why they call it the short certificate. It's got virtually the same information as the original, but no one ever asked for the original. They're always asking for the short certificate. That short certificate is a legal document issued by the courthouse that verifies several things. It verifies when someone passed away. It has their social security number on that document. Most importantly, though, it verifies who was appointed to represent the estate. And it talks about the granting of letters to someone. So either letters testamentary would be granted in the case of a will being admitted by the courthouse, in which case, again, that the person or persons named on there would be executor or executrix, or talks about letters of administration being issued. That's a situation where there was not a will, but again, the court has appointed somebody to be legal representative of the estate, and again, that would be the administrator or administrators.
So from a process standpoint, it's somebody walks in there with a will or the attorney goes in there. Is it easier to be appointed as an executor than an administrator? Is there something else that has to be done to get them named as an administrator if they were not appointed by the deceased?
Yeah, I mean, easier. It all depends, I guess.
Okay.
It's usually easier if there's a will, an original will that has been properly signed, has, all the T's crossed and I's dotted, for the courthouse to, recognize that document and appoint somebody and issue that short certificate. That's usually easier.
So from the look on your face, that's not always the case.
But it's not always the case.
Okay.
Yeah, and you probably don't want me to go too far in the weeds about that, but people do their own wills. people handwrite handwrite their wishes. Sometimes the interpretation of those things can get pretty complicated.
Okay.
So, but again, the short certificate is the document that would prove to you, are you talking to the right person? Okay, so for any estate, that's who you would need to talk to, and ultimately that person or persons are going to be the ones that will have to sign documentation. Okay, they should be the ones signing any agreement of sale, any listing contracts, and ultimately any deed and other settlement paperwork.
Okay.
Okay. It could be important to also, if there is a will admitted, and again, you would know on the short certificate, it would say letters testamentary have been issued. It may be important to see a copy of the will, because if in the will, property can be specifically devised to someone. So, if they left their property at 100 Main Street, New Cumberland, to their nephew, then really the role of the executor or the administrator is to be transferring the property to the nephew, and not to be, signing a listing contract and putting it up for sale to the general.
Here's a note from the broker. It's not your job to interpret letters testamentary or wills. And in these cases, we want to be having that talk with the estate attorney. That's, we have to be very careful not to practice law. That's not our job, and we need to steer as far away from that as possible. So that's why whenever we're selling real estate, I really, really want an estate attorney to be involved in this. And if somebody's passed away and an executor or administrator wants to save a couple bucks,
And they all want to save a couple bucks.
This is where we get into trouble, is we start trying to help them through things that we are in over our depth on.
Yeah, and I think that's a good point. Unfortunately, you'll probably run into situations where there isn't an estate attorney. My experience has been, usually people can get to a certain point when someone's passed away, and that point can be pretty quick or pretty long, but usually they will get to a point where they realize they're in over their heads and need some legal guidance, because it is fairly complicated, honestly. Whether attorneys made it that way intentionally or not, I'm not saying, but
That's the way it is.
But that's the way it is. That's exactly right. All right, so we talked about who should you be talking to, what documents, and again, I think death certificate, short certificate, probably copy the will, and even if you're not interpreting those things, gathering those things together to pass them on to whether it's an attorney or whether it's a title agent, those are things that will be helpful to make the process smoother.
Okay.
Okay. Final question is, why is this stuff important? Well, it's important because you want to you don't just want to get a listing, you want to be able to complete the listing and get paid. So from your perspective, that's why it's important. You want to make sure everything can go through without any hiccups. From the legal perspective, though, it's primarily, it's all tied into title, right? The seller needs to be able to convey clear title to the buyer. And particularly with estates in Pennsylvania, the law is that any estate tax, any inheritance tax that's owed, and there is inheritance tax in Pennsylvania, despite what some people think, that is an automatic lien against the assets of a decedent. So real estate a lot of times is the asset that sort of ends up being the key asset for people that own property. Any inheritance tax obligations are automatically liens on property when someone's passed away. So going through all this process ultimately is to make sure that there's not any lien on the property, that again, we're getting clear title to a buyer.
We've encountered some really tricky situations when it comes to inheritance tax. I believe it was a property in Perry County that was owned by 5 sisters.
Mm-hmm.
And their individual shares kept on passing down. Nobody was ever involved, and where one share, where those shares were combined over time to one owner who went to sell them, none of those estate or inheritance taxes had been paid on the other 4 shares.
Right, and that's an excellent point and a great example of how this can be complicated and how this third point kind of ties back into the first point. So even though you may have a property that was owned as joint tenants with right of survivorship, and no estate was opened at the time that someone passed away, there is still inheritance tax that's owed for that person's share passing to the other joint owners.
Right.
Okay.
So,
And the other thing that's confusing, because people are like, well, there's nothing filed of record at the courthouse, and that's correct. Department of Revenue does not file. In rare situations they do, but in general, they don't file anything at the Recorder of Deeds office, nothing at the Register of Wills office, nothing at the Pathonetary's office. It is written into state law that those inheritance taxes are an obligation of the estate, or fall onto the assets of the decedent, and so they're going to have to be paid, just even though there's no paperwork perhaps filed anywhere at the courthouse.
does the value of the property have anything to do with the amount of the inheritance tax?
Absolutely. So inheritance tax in Pennsylvania is a percentage. The percentage varies depending on who the beneficiaries are. Just real quickly, for spouses, there used to be inheritance tax. They basically got rid of it by dropping the rate to 0. So technically there is inheritance tax, even if it's passing to a surviving spouse, but it's at 0%. So there's not really anything to pay there. But for any lineal descendants, so if that's children, grandchildren, great-grandchildren, or if it would be going up the chain to parents or grandparents, it's 4.5% of the value of the asset at the time of death. For siblings, it's 12%, and for anyone else, it's 15%, whether that's more distant relatives or people that are unrelated.
Now, Doug, that's not just real property, but that's all property. So that could be bank accounts.
It's pretty much everything. There are some exemptions in Pennsylvania, some assets that are exempt from inheritance tax, but the list is pretty short.
So that inheritance tax, if there's a lot of assets outside of the real estate, it could be disproportionately high inheritance tax that would be leaned against the real estate. So if there was a lot of cash in a bank account, that would be taxed, but that would be withheld then from the real estate proceeds.
It could be. That's an issue that a lot of times ends up being discussed, leading up to settlement. How much, if the title agent thinks any money needs to be escrowed, how much needs to be escrowed? And they would normally, as part of their search, look and see, has an estate been opened? Have there been any payments towards the inheritance obligation? What's on the paperwork that maybe is filed to that point? What values have been claimed, for assets that the decedent owned? So all of those things would be part of that discussion normally to figure out what, if any, amount needs to be held in escrow.
Okay.
What if the beneficiary of everything is a charity, a 501c3?
So then there's no inheritance tax on any charitable interest. But
So the bills get paid and then the rest just goes to the charity.
Correct. So there probably wouldn't be a need to escrow any funds for inheritance tax obligation, that sort of situation. But even so, I think you'd want an attorney looking at those documents. Because we've run into situations where, well, let me back up again. So when charities are beneficiaries, there are some exceptions, but primarily the Attorney General's office in Pennsylvania, their charitable organizations division now needs to step in and make sure things are being handled properly. So there's some other hoops that you would normally have to jump through, even though there might not actually be inheritance tax to pay.
Okay, that's all in progress.
So you have an actual situation that's happening right now, MJ.
Yes, there is an attorney who drew up the will. There is an executor who's being monitored and helped by that attorney. And she will handle, I'm going to be listing the house. And she will be handling any issues concerned with the estate. Once the loan against the property and any other bills of the estate, which are looking to be quite minor, are paid, all the personal goods in the property were either given to that charity already for their disposal or have been given to a reputable local auctioneer to auction off. And those monies are already basically accounted for. So I think we're good, but there is no inheritance tax escrow necessary, probably.
There should not be, yeah, and I would think that sort of situation would be, pretty easy from the realtor perspective.
It has been so far, definitely.
Yeah, so, I don't think there's a ton of those, wills out there, but, I've written some, myself, and, if you can corner the market on, no beneficiaries except for charities, that's a pretty good deal to have.
Right.
Except for the decedent.
Well, yeah.
Doug, I know. Oh, somebody at home.
I do have a question about a couple questions. I thought I read somewhere, I had something similar to this, where if somebody deeds a property, I had something sort of like this, joint tenants with right of survivorship last year. If a property is deeded within a year and a day, is inheritance tax sustained regardless of timeline, or does that go away after a certain amount of time?
So if someone transfers an asset for less than fair market value within a year of their passing, it's still subject to inheritance tax in Pennsylvania.
Okay.
And yeah, wasn't even thinking about this, but you guys may run into this situation. People come into my office all the time and they're like, we want to transfer our house to our kids or, whoever, we want to add them onto the deed. Well, is that something we should do? The answer is it depends. It really does depend. Sometimes that can make sense. Sometimes that can actually put people in a worse tax position. It's really something that needs to be kind of thought through and discussed with an attorney who understands the ins and outs of doing that. But yeah, if someone if they gift if they're selling the property for fair market value and then they pass away less than a year from that transaction, there's no issue. But if they're gifting the property or adding someone on as an owner, and they pass away before a year's time has gone by, there's still inheritance tax obligations on.
So there's a look back on that.
Correct.
So
It's basically to prevent someone on their deathbed to say, well, I'm giving everything to Johnny, so that he doesn't have to pay inheritance tax.
right. Okay.
The state shut that down a long time ago.
There's a similar.
Before I was born.
There's a similar look back on, if somebody's going into the county home,
Correct.
that's a 5-year look back, right?
Correct. So if someone is applying for medical assistance, they will have to disclose not only what assets they own at that moment, but 5 years leading up to that moment.
Okay.
And basically the state if you had assets that you transferred for less than fair market value, they will look at those as still assets of yours before you're going to be eligible.
So the moral of the story is the tax man gets his.
Yeah.
Okay.
Yeah.
All right. Kristen, you said you had another question, maybe?
I have a follow-up question. When you say the inheritance tax, you said at the market value at time of death. I did get this question. It is whatever the home, the inheritance tax is the entire amount of whatever the home is sold for. Let's assume assuming it's a real estate typical real estate situation. And you've sold this home, I'm just gonna throw a number out there, for $200,000.
Right.
My client was rather irritated because there was not fees, like real estate fees weren't deducted. There was a mortgage on the property that wasn't deducted.
No, all those things should have been deducted, but that is happening when the inheritance tax return itself is filed. And usually that's happening after settlement, not prior to settlement. There's exceptions. Some people are in a rush to get those done. I usually think it's better to wait. Let's get the property sold. Let's know exactly what the sales price is going to be and what the net proceeds are, because realtor commissions are deductible on the inheritance tax return. Real estate tax obligations that need to be paid at settlement are deductible. Your final water sewer readings, even utilities, which don't normally show up on a settlement sheet because they're not lienable items, are usually deductible on the inheritance tax return.
So it's on proceeds, not sale price.
Right, so it's on the net, should be on the net. You look at the inheritance tax return, it talks about net value, net assets subject to tax.
Okay.
So it's not on the gross sales price. It should be really on the net sales price. Now, you can't be too tricky on your deductions, or revenue is going to slap you, but.
Yeah.
Right. Well, and this is where I would completely get out of my lane, because in this particular situation, she was absolutely adamant that she did not need an attorney. So, and she did ultimately need one. So these are conversations I wouldn't necessarily, I'm just trying to speak in sort of vagaries before I would send a client off to, strongly encourage, a real estate attorney at the end of the day. So okay, so you deduct fees out, my $200,000 example, you take fees away, and then you're let's say it's $50,000. So you would then, after settlement, be taxed basically on 150,000, or you'd be taxed all up front. They would hold up front in escrow on 200,000, and then those items would be deducted post settlement. Am I understanding that correctly?
Well, the escrow rules really come down to who's the title agent, who's the person handling the settlement and issuing, any title policy, or when there's not lenders, sometimes they'll do an attorney's certificate of title. It really depends on what their comfort level is with things. And it's very common for me to be negotiating, if I'm handling an estate, representing an executor, negotiating with the title company or title attorney as to how much money we're going to escrow.
Okay.
I think the trend has been to be more conservative. So people will be calculating inheritance tax based on the sales price, not based on maybe what the net value is.
And the reason that they might be escrowing is if that obligation isn't met with Department of Revenue, that's a lien on the property.
Correct.
That's what they're worried about.
Right.
That ultimately is not going to be taken care of.
Right.
I know personally too, I usually try and negotiate the release of the escrow when we get the inheritance tax return filed, not because in Pennsylvania, it's usually 4 to 6 months, and usually more like 6 months until revenue will respond back to a filed inheritance tax return.
You typically hold an additional 1.5% as well. As that standard?
Yeah, whatever number they pick, a lot of people will then say 1.5 times that.
Okay.
So, but again,
And the scoop there is just like you just said, just to deliver clean and marketable title, because then it goes back to the law office or title company or whoever it was when a lien pops up, however long from now.
Correct. And again, in this situation, it's not really that the lien pops up. There's not paperwork that gets filed anywhere with revenue saying we have a lien for X amount. It's
Right.
just by law, they have a lien the moment someone passes away.
Okay.
Got
And
it.
so that 4 to 6 month time frame to get this inheritance tax return filed and finalized.
Yeah, well, that's more just the response. So there's generally 9 months from someone's passing to file the return. But once the return's filed at the courthouse, usually takes revenue 4 to 6 months to issue their determination letter.
And that's somebody who knows what they're doing, filing this in a streamlined manner, not somebody who's never navigated the Commonwealth of Pennsylvania.
Correct.
Right. So when talking with your clients and they say, I can do this myself, can I? This is when we say, do you know what you're getting into? Or you probably don't know what you're getting into. You should talk to an attorney to make sure that you're, dotting all your I's, crossing your T's, and you're not leaving money and time on the table. Because this is frustrating for people, even when there's an attorney to guide them through it. To do it by yourself, you're likely to make this take twice as much time and could potentially cost your client money.
Yeah, and that's absolutely true. And there's still a percentage of people out there that will absolutely not believe you. So they don't believe me when I tell them.
They're called for sale by owners, but okay. Is it one last curveball? How does trusts play into this? How is a trust relate to estates and taxation and the transfer of property?
So again, the answer is it depends.
Right.
But most of the time, when people are talking about trust, they're talking about living trusts. And you probably heard that phrase before, I would imagine.
Yeah.
Or legally, they're technically called revocable trusts or revocable living trusts. The short answer is that doesn't change anything that I just talked about, other than maybe who would be the person signing the paperwork. You may have a trustee as opposed to an executor signing the paperwork, but all the other stuff we talked about, inheritance tax and everything else, still applies.
So,
And unfortunately, there's been a lot of people who have sold these living trusts telling people it's going to save them tax. It can save tax, but it does not save inheritance tax.
that's the point I wanted to get across. This is
Thank
not,
you.
not a get out of jail free card. This does not skip you to the head of the line. This is not the world's best kept secret.
No, and I can tell you multiple cases where, we get to the end of the process and, my clients are like, why do my parents ever set this up? It's just made things more difficult, and I don't really see that saved us anything. And a lot of times they're correct. Again, there can be reasons why, trusts would be set up, and there's lots of other different types of trusts. I mean, there's irrevocable trusts, and the rules on that can be different because they can't be changed. If it's irrevocable, that means the person that's setting it up can't change it later on, or for the most part can't change it later on. So those can be a different animal, but usually what you're talking about, or what you'd run into is these living trusts, or revocable living trusts.
And I've had plenty of clients tell me that was done to avoid paying inheritance tax.
Correct, and
Yeah.
that is absolutely incorrect.
Uh,
There was a reason. There's also potentially, when someone passes away, if they're a resident in Pennsylvania or they own real estate in Pennsylvania, there's Pennsylvania inheritance tax issues that need to be dealt with almost all the time. There's also federal estate tax, and that is very different. And it used to apply to a lot more people, and those living trusts could be helpful to navigate the federal estate. It's actually federal estate and gift tax is what it's called. But currently the exemption amount for everyone in the United States is over $11 million. And so you double that if there's a spouse, that's not going to apply to very many people anymore.
most of my family school.
Yeah.
all,
Now,
all family
They
altogether.
threaten to monkey with that all the time, and they very well might, but at least at this point, that's probably not going to be anything you guys run into.
Very good. Any other questions from our remote listeners? one of the reasons that I invited Doug and always invite people who are real estate adjacent to talk about what's going on in our industry is to scare you. I want you all to know, that this is not as simple as it may seem from the surface, and that whenever you're having a discussion with a client, this may throw up a red flag for you to reach out and ask a question to somebody who's more qualified in that particular sector. So if you're paying attention, you should know that there's a lot more below the surface than even what we skimmed across today. But that's the value of having professional partnerships, especially with real estate and estate attorneys. Anybody, anything?
Well, one thing I'm going to do is put in a small plug for the SRES designation, whether you're a very senior like myself, or you're just getting started. What that course will teach you is not how to fix all this stuff, but that all this stuff exists and that you do need sources. It's a good course.
Very good. Thank you, MJ. Okay,
I just have a question,
yeah,
please.
sure.
The difference between just assigning a power of attorney and a trust. I know the reasons for creating the trust, but if it's just a matter of the convenience for a power of attorney, is that suggested, or is that,
What's the difference between a power of attorney and a trust?
yes,
I mean, they're completely different documents. I would need to know, I would need to know what the intent of the client is, what are they trying to achieve? And when you get into powers of attorney, there's actually many different types of powers of attorney. You can have more than one agent named for different things with different powers of attorney. So, again, there are different documents and different legal reasons for having those documents. I don't know if I can give you a more specific answer than that without knowing more information, but
Again, it depends. Right.
thank you.
sure. Yeah, good questions, everybody.
All right. Well, if there's nothing else, we'll let Doug get on with his day. We thank him. If you have questions, I'm going to send you out contact information for Doug. If you run into a client who does not have an estate opened and they have real estate to dispose of, he's your man. So please, if you have questions, reach out to me and use the resources that we provide for you, everybody.
Thank you.
Have a great day, everyone.
Thank you.
Bye.